So have you been thinking about putting your assets in your kids' names to protect them or to simplify things later? Well, this is a common move, but it could seriously backfire and cost your family big time. By the end of this video, you'll understand the risks of putting assets in your children's names, the common mistakes people make, and better alternatives to protect your family and your finances. I'm estate planning attorney Mike Smith with Smith Barid LLC, and I've helped thousands of families over the last 28 years avoid costly estate planning mistakes like this one. And today I'm going to help you avoid it too. Stick around because I'll also share a smarter way to protect your assets that can save your family thousands in taxes and legal fees. So why do parents want to put assets in their kids' names? Well, many parents think they're doing the right thing, but here's why this approach, which seems smart, often might not be that smart. So parents often believe that transferring assets now avoids the hassle of probate later. And that's true. The idea is just to make it easier for kids to inherit without legal complexity. Some people also think that putting assets in their kids' names shields them from creditors or nursing home costs. For instance, a parent might add their child to their home's deed, thinking that this will avoid delays and expenses after their passing. So let's talk about what are the risks. Here's what most people don't realize. Putting assets in your kids' names can actually create bigger problems than it solves. The first thing is you lose control. Once the asset is in your child's name, they technically own it. Or if they own it jointly with you, you got to get their permission to do anything. So this means they could sell, mortgage, or even lose the asset due to some sort of financial difficulty. And all that's without your consent. So if they have a car wreck and get sued and they don't have enough insurance to cover the damages on that, then your bank account, your house, your assets could become subject to that judgment. And that's not what you want. You basically expose yourself to your children's liabilities, their creditors, lawsuits, even divorce settlements if they are on your assets with you. So I know a lot of times bankers will suggest, hey, just add your kid to your bank account. And I think of that like sort of the tip of the iceberg. All you see is, well, that makes it a lot easier on a day-to-day basis to have my kid be able to get into my bank account and pay bills and that sort of thing for me. But what you're missing is all the stuff down below the surface. And one of those big things is that you're exposing yourself to your child's liabilities. There are also tax consequences. So if your child inherits your original purchase price as their cost basis, it means they could face hefty taxes when they sell the asset. So let me back up a little bit and explain that a little more simply. So capital gains tax is a type of tax that applies when you have a capital gain in selling an asset. So let me give you an example. If you buy a piece of property for $100,000 and you sell it for $1 million, you have a $900,000 gain on that piece of property, and you pay capital gains taxes on that gain. Okay, so that's, in a nutshell, how capital gains tax works. Now, the other thing to know about capital gains tax is that when you inherit something, you might be able to avoid the capital gains tax. So how does that work? Well, let's take that example I just used of your $100,000 property that's now worth $1 million. If you give that to your child and they sell it for $1 million, they have exactly the same capital gains tax consequences that you do. So they're going to have a gain of $900,000 and they're going to pay capital gains tax on that, either short-term or long-term. Now, if they inherit that property from you, then they receive what's called a step up in basis. And that means that their basis in that asset is now that $1 million value. So if they sell it for $1 million, there's no gain. There's no gain. So guess what? No capital gains taxes. So that's one of the things that people often don't think about is that, well, there could be some capital gains tax consequences. And while a lot of us are not impacted by the estate tax right now, thank goodness, we are all impacted by the capital gains tax. So it's important to keep that in mind when making decisions about transferring assets to your children now rather than allowing them to inherit through your will or your trust. Now, the other thing to know is that a transfer while you're alive may trigger gift taxes. Now, you have an exemption to gift taxes. It's the same exemption you have from the estate tax, so it's currently $13.61 million. That's a lot, but Every time you make a transfer that's over the annual exclusion limit, that counts against your lifetime exemption from gift and estate taxes. And you have to file a gift tax return. So even if no taxes are due, you still have to go hire an accountant or somebody to file that gift tax return, or do it yourself if that's what you'd like to do. But it's important to just understand that there are gift tax consequences to making a transfer during your lifetime rather than through an inheritance. And it's not, doesn't mean you shouldn't do it. It's just something you want to know and keep in consideration as you're trying to make a determination about how best to handle your assets. The other thing to know about is that there can be Medicaid penalties for transferring assets within 5 years applying for Medicaid. So when you file the application, it asks the question, have you made any asset transfers in the last 5 years? And if the answer to that is yes, then they take the value of the asset transfer and they divide that by a penalty divisor to come up with the number of months penalty that you have to serve. I know it sounds complicated, but what it means basically is that Medicaid won't pay for however many months that is. So if you make an asset transfer and then you need to go into a nursing home less than 5 years later, it can cause problems for Medicaid qualification. So that is something where if you plan ahead of time, if you anticipate that you're going to need nursing home care, you can do those transfers and get past that 5 years. But that's something that often people don't know about, is the Medicaid penalties that can apply if you transfer assets to your children. So instead of putting assets in your kids' names, what can you do? Well, here are some better strategies that truly protect your family and your finances. The first one is a revocable living trust. A revocable living trust keeps assets out of probate while you retain full control during your lifetime as long as you're competent. And it allows for a smooth, private transfer of assets to your kids after you pass away without having to go through that court probate process. The second thing is an irrevocable trust. And there could be cases in planning for Medicaid, for example, where an irrevocable trust is the right way to go. It protects assets from creditors and it can help you with Medicaid planning. It's ideal for long-term planning if shielding assets is a top priority. The third thing is beneficiary designations. You can use tools like transfer on death deeds or payable on death accounts to pass things directly to your children without having to go through probate. So let's talk about how that would look. Imagine you set up a living trust for your home. You stay in full control while you're alive and you're competent. Your kids can inherit it seamlessly after you're gone without having to go through probate, deal with any judges or courts, and they avoid paying any unnecessary taxes. Sounds like a great plan, right? So there's some common myths I want to talk about too. If you're not convinced yet, let's clear up some of the biggest misconceptions about putting assets in your kids' names. Number one, it's the fastest and cheapest option. The reality: probate can still be avoided with trust or beneficiary designations without risking losing control of the assets. Number two, it protects my assets from creditors. Well, creditors can still go after the assets in your child's name. Trusts are far better protection for assets. Number three, it won't affect my taxes. In reality, both gift and capital gains taxes can be triggered by transferring assets during your lifetime. So to recap, putting assets in your children's names might seem like a simple solution, but it can expose your family to unnecessary risks, taxes, and legal issues. Like I said, I think of it as sort of the tip of the iceberg, and it's all that stuff down below that you have to be concerned about. Trusts and beneficiary designations are often much better options. If you want to learn more about protecting your family's future, check out our video on setting up a living trust, estate planning facts. I'm Mike Smith with the Estate Planning Guys. We'll see you there.